Our conversation today is all about the Constitution. We want to look into the future. Okay, talk about Constitution, governance, look beyond the upcoming elections, and really ask these fundamental questions about whether our problem as a nation is the Constitution. All these hurdles we've come up against and been unable to overcome. Is it because there's some fault with our Constitution? Will fixing that fault solve all our problems? Or do we need to be looking beyond that? Professor Kofi Abotsi is our guest this morning. Of course, he's the Dean of UPSA's Law School. Very prestigious law school indeed, especially since he became Dean.
Thank you.
Yeah. So, Prof, I guess we can start from the beginning. The 1992 Constitution, it was the result of a promise, if you will. A promise to improve the lives of Ghanaians. We felt that having constitutional rule would lead to development, and there would be dividends that we would all reap from this. So we saw it as more than just a list of laws, more than just a documented guideline to how to live. It was the blueprint to our development. How far with that one?
Well, I think you've asked an important question. First of all, it's perhaps important to put it in context that in 1992, we had a transition from a military government then headed by the chairman of the PNDC, former President Rawlings, and then we came into the 92 constitutional arrangement. The epochal divide, therefore, splits into two, in which you have a directional leadership under a military regime, transitioned to a participatory governance model in the Constitution. So what the Constitution did was to transition us from a directional leadership in which we had no say but were directed. We were told what to do on a daily basis, and we basically just had to follow, to a participatory governance model. And the participatory governance model is both in the area of the civic participation, the economic participation, the political participation, and other participation, but essentially the civic and economic as well as the political. I think if you ask people generally, and I haven't taken a poll, but if you ask people generally whether the 1992 promise of constitutional rule delivering public goods, and when you speak of public goods, you're speaking of political public goods, civic public goods, economic public goods, whether the 1992 Constitution has delivered on the promise of giving public goods to Ghanaians, I'm sure you probably have some mixed reaction, in the sense of there may generally be an acceptance that the civic participatory space has improved, because there was none before 92. And where there's close to zero, anything that comes is an improvement. So that area certainly has been improved in terms of people having the right to say whatever they want, people having the right to join any association they would like to join, and people
can be part of democracy.
Right, exactly. So in terms of the civic aspects of things, there appears to have been some delivery to a degree. I think there's likely also to be, and again, these are all my assumptions, but I think there's likely to be a general consensus also that the economic aspect of things, the state's presence in the economic and social lives of people, the avoidance of social dislocation, which is one of the major failures of states, i.e. the fact that you belong to a state, but you really don't belong. And the state essentially doesn't give you much. I think there will be a general consensus to a degree that extent may not have been as successful as one would wish. I've indicated elsewhere that when former President Kennedy of the United States famously spoke of ask not what your state can give you, but what you can give the state, there was an assumption that the state will invariably give you something through the collectivity, because the state is really all of us. The state invariably will give you something through the collectivity, your payment of taxes, etc. The state invariably will give you something, the road you drive on, the public utilities, and all kinds of things the state gives. So do not ask the state for anything, because you will get it. The state is you. That assumption is already there, and that's why he emphasized rather you should ask yourself what you are giving the state. But when the state fails in terms of giving you a certain minimal social life to avoid dislocation and to ensure that the totality in numbers leads to cross-subsidization in a manner that everyone benefits. When the state fails at that level, that's where you have foundational questions, foundational issues, and I think those are some of the things that you mentioned in the earlier question.
So, well, here we are. We have this constitution. We've had it now for 31 years. I suppose it is fair to now ask, this failure to develop in so many aspects of our nation's growth, this failure to develop a sustainable educational system, a healthcare system that can look after all Ghanaians, an infrastructure that leads to industrialization and maximizing of the manufacturing sector, a failure to substitute imports, all these big national problems that no matter who we vote for, we never seem to solve. Is the problem the constitution?
To understand and to answer that question correctly, one needs to understand also the broad framework of the Constitution. The Constitution, generally, you split it in two parts if it's a skeleton, and you find on one part power centers. You find on the other part control centers. And then you find somewhere in the middle broad provisions of social goods. The power centers are the centers of the Constitution where the Constitution has created power and authority. And so, for example, Article 58 creates executive power in the President. And then Article 93 reposes legislative power in Parliament, and then the judicial power in the judiciary. And then there are a series of other power centers that are created across the Constitution. Then you have the control centers. The control centers are supposed to be the centers that are to rebalance and to counter those power centers. It simply means that the Constitution framers understood the fact that you needed to create power. But again, a wise man once said, you quoted a certain wise man, but a wise man once said that, if people were angels, there would be no need for government. In other words, it is fundamentally in the character of human beings, and these same people are the ones who go into power. It is fundamentally in the character of human beings and people to want to go beyond and to do excesses, whatever it is that is conferred on them. So the Constitution framers understood that you need to create power. However, you needed to constrain the power. And so constraints have been created by way of checks and balances, which is generally well known. The problem with the Constitution, it seems, is that its operationalization has exposed, in my opinion, what really is in the nature of our problems, our tendencies towards corrupting power, tendencies towards exploiting power, and tendencies towards using power for private gain. I think one of the biggest problems of the Constitution over the years, as we've seen, is the corroding and the corrupting effect of party politics. And I think that this is one area the framers of the Constitution underestimated. I think if you look at, for example, the provision on political parties starting from Article 55 onwards, you will get a sense that there was a certain general assumption that political parties and political parties forming governments will naturally act in the best interest of Ghanaians. There was that general understanding or that general sense. I think what the framers of the Constitution perhaps underestimated is the nature of our political party history. There is a certain serious historical problem of our political parties in Ghana, which started all the way from the UGCC. And you'll be surprised that those historical dynamics are with us today. They continue to reflect in the relationships of the parties. And so what we have is a tendency for these parties to dig in and to create sectionalism, in which members of certain political parties, when they are in power, it is their time. And when they are out of power, whoever comes, it is their time. And there's a tendency of us against them, and there's a tendency of a cycle in which there's a benefit. This cycle is over, the new cycle begins, and this new cycle members, the members of the party must enjoy. So, if you ask me, I'll repeat again that the problem fundamentally is not the Constitution. And I've said this before, that Constitution reform can only do so much. Look, no matter how much you engineer constitutions, lawyers spend their time dissecting and understanding the weaknesses of the new design. and you will invariably find the weaknesses of the new design. It is the reason why the United States hasn't necessarily gone the path of rampant constitutional changes. The constitution of over 400 years have had very few changes to the constitution, and you can name them. Very few changes to the constitution, the famous of which is the 14th Amendment, but very few. They can name, the number is not much. And so the United States has understood that to really ensure constitutional governance, the black letter law itself does very little. And therefore, where you can have much success is by way of evolution and interpretation. So you build constitutional ethos. There's a book written by a guy called Lawrence Tribe. Lawrence Tribe is a famous American constitutional lawyer, in which he spoke about the unwritten or unseen constitution. That the real constitution is actually the one you don't see. And that real one is in our heads. Because you ask yourself that in reality, constitutions are fictions. I mean, we woke up one morning and then we gave this constitution the authority. So what makes us think this constitution is over and above us? We have decided to make it over and above us because in reality, it is a certain fiction, a certain legal mythology. And that legal mythology is generally accepted and we all follow suit. So the foundational strength of constitutions and constitutional rule are really in our heads. When a people do not have that constitutional ethos, you don't do much. And I think that unfortunately over the years in our country, our leaders have seen the constitution as a document that has to be negotiated around. And when you have that mentality, we will always point to the text to say that the text allows us to do something. And we do not necessarily ask the question whether what the text allows us is functionally beneficial to overall governance. And I think that's part of the problem we have.
So just what you just described, is it a text that is supposed to get the leaders to think that way?
It is not the text. As I indicated, if you look at the Constitution from the very beginning, Article 1, Clause 2 says this Constitution is supreme. Any other law which is inconsistent is void. And then the Constitution goes on and on, including the directive principles of state policy, in which leaders are actually urged to think Ghanaian and to think visionary in the context of Ghana. Overall, the Constitution, in my opinion, has done as much as it could for any leader to be able to use that document for the transformative benefit of Ghana. It is not the text itself. As I indicated, it is the ethos. Now, I feel a bit helpless in this context because some things can barely be taught and some things can barely be written. Ethos and therefore ethics, in broad terms, are not things that you can necessarily ingrain in people. It is something that has to be nurtured. It is something that has to be grown with. And that's what I'm saying, that it appears that the problem of the Constitution is one with us, which has been a leadership situation right from the beginning of the Constitution till today.
Right.
And that leadership situation, in many cases, actually precedes the Constitution, goes way back into our historical times, in which our governance model and our governance history has been one in which you have had two political parties which have evolved in different ways into different political parties today.
Right.
Digging in and getting a sense of ownership, one, of the political terrain, and two, getting a sense of a sectional mindset. That sectional mindset, if you have a sectional mindset, the Constitution has to benefit the section. And that section will have to, from time to time, exploit the Constitution to the maximum benefit of those who are involved in that section. I think that sectional mindset, in my opinion, is part of the reason why the constitutional ethos is not imbibed.
Right.
Members of that section want to maximize the benefits of the Constitution. And once you want to maximize the benefits of the Constitution, not for the sake of the Constitution, but for the sake of the section, you're invariably likely to have some of these
So
challenges.
I just followed up with that because, we have a provision that requires public officers to avoid unethical behavior or conduct. But now we're battling with that. We're looking for a code of conduct for public officers. And you're wondering, can we possibly write out everything? Can't they just, because you're a leader and because there's a broad provision like that, can't you simply just do the right thing?
Absolutely. The provision on the code of conduct of public officers, admittedly, is very scanty. Admittedly, it barely spoke about conflict of interest, and so that one can be expanded on by way of legislation. And we've had legislation that expands on many of these constitutional provisions. So I have no problem. But you also again hit the nail right on the head that even if you do modify or amend the constitution, the reality remains that the statute that you come up with can always be negotiated around. The thing is, legislations are fundamentally imperfect documents. You can never ever have a perfect legislation. You can never have a perfect constitution. And if you can't have a perfect constitution, it means there's no way you can amend a constitution into perfection. So human ingenuity will always be a step ahead of the law. And if human ingenuity will always be a step ahead of the law, then the target should be that ingenuity, which is the manipulative tool. I have no problem with Ghana's constitution being modified to a certain threshold and to reflect some needs of our current time, which may not have been there in 1992. But focusing on constitutional reform, I think, has been the wrong approach.
We're talking to Professor Kofi Abotsi. We're talking about the big thing, the big question, the Constitution. Is it really the cause of all our problems? Can we amend our way out of the big insurmountable difficulties that as a country we've been grappling with? Now, he's already made a very interesting and important point, that the real Constitution is unseen. It's the one in your head, the one that guides your actions, whether or not it is written somewhere that you must do A or B. The real Constitution is in your head. So the problem perhaps in Ghana, according to Prof, is that maybe not enough of us have a constitutional ethos. Now that's interesting, Prof, because if really the problem here is a lack of constitutional thinking, constitutional mindset, constitutional ethos, that means chances are whomever we choose to lead us is going to have the same problem. He's going to be a person, he or she is going to be a person who doesn't have that constitutional ethos. Is that not the more reason why we should limit the amount of discretion we give to a person who doesn't have constitutional ethos?
That would be the simple approach, if you ask me. And the reason is the simple approach is to say, well, if the power wielder cannot be trusted, then let's limit his powers. It's a simple approach. The reason it's simplistic is because you may be solving one problem and creating another. Constitutional discretions are there for a good reason. They are there because leaders must fundamentally, on a day-to-day basis, think of options by way of policy preferences. Those policy preferences cannot be stated in hard law in detail, because society is complicated and complex, and you can't put things in a rigid format. If you do that, government will grind to a halt. That's what the political scientists will tell you, that if you take away discretion and you list everything in detail, government will grind to a halt, because new and emerging situations will arise, and those new and emerging situations would not have been taken care of. So discretions are fundamentally important. What is also important is therefore the constraining effect of discretions, and that brings me back again to how I began, splitting the constitution in two broad parts: power centers, control centers. That brings in the control centers. So the discretion is a power center. It's a center that allows decision makers to decide or to choose between alternatives and to say, I prefer A and not B. The question is not whether you prefer A or B. The question is why you prefer A over B. What are the cost analysis, the cost-benefit analysis of preferring A over B? What are the dangers? What are the risk effects? What are the various calculus that goes into that? And let's also ask, what are the private benefits of choosing A over B? These are the questions that Mamavi's issue of the conflict of interest, for example, the issue comes in. So the fundamental question is not necessarily taking away the power. Power is good and is conferred for a purpose. The question is how the power is exercised, and when the power is exercised, the question then is how the control centers kick in. Ghana's constitution is replete with good examples of control centers. Again, these control centers over the years have been mastered by the political class. So it goes back again deep into the history I speak about, the sense of the executive constantly seeing and viewing these control centers sometimes as opposition in some ways, and therefore how they need to be mastered and how they need to be tamed. So we've had many instances of even Chief Justice. We've had a Chief Justice in Ghana, against whom the Ghana Bar Association went to court to actually challenge his appointment. And that tells you the tensions that exist sometimes even in the appointment of heads of certain organs of government. We've had complaints about key persons who have been appointed and who may have been dismissed and which have been challenged and have become the subject or objects of judicial decisions and therefore court action in this country. So the reality is, control centers are designed principally to balance power centers which are inevitable. Because if power centers are not inevitable, then you simply take the power, as you're asking. But if you take away the power, you would have deprived the power wielder the very instrument of his office, which is the purpose for which he's in office in the first place.
Yeah.
And so he will not be able to be as effective as one would hope. So the power is necessary, but to deal with the power, one needs control centers that are effective.
Can I just ask about, just before you go, what these control centers are? I take it that the Electoral Commission, for instance, the Judiciary, Parliament, state institutions, Auditor General, are these institutions effective today? Are they effective control centers?
In fact, I will ask Prof to answer that question for us when we come back from the break, because I suspect there's a lot for us to get into there. So we'll talk about control centers, we'll talk about institutions that are supposed to be autonomous, right? And whether indeed they are. We'll talk about a few of the recent judicial decisions, all right, and how they affect governance. Justice Atuguba, famously made some very interesting observations about the Supreme Court. Prof, we'll get Prof's take on these, and then of course we'll look into the future. What should be the agenda of political parties as we go into this next election, and what should you, the voter, be listening out for if you want to choose a leader who has the most constitutional ethos? Professor Abotsi has already pointed out that indeed the real constitution is the one in your head, the one that guides your actions, the one that you rely on to decide between right and wrong. And the one that is written is the one that we have just chosen to hold above our daily lives, to hold as our guiding document. But the question is, how do we fix these perennial problems that our nation faces? Is it by improving the constitution, or should we improve the actual mindset with which we apply that constitution in our daily lives? Now, just before the break, Prof. Abotsi made a very important distinction between the power. Did you say power factors or power centers?
Power centers.
Power centers and control centers of the Constitution. And Mamabi, you started to explore the question of the control centers of the Constitution. Prof, I guess you can take that one.
Well, the question as to whether they have been effective, I think, can only be answered by reference to their mandates. And I think the mandates of control centers, broadly speaking, are to check either specific entities in respect of which they are designed to check, or to broadly check the realm. In the case of the judiciary, for example, broadly check the realm. I think that the answer can be yes and no. Yes, to the extent that there are circumstances where indeed they've been very effective. There are circumstances where decisions of the courts have constrained executive actions. There are circumstances where the outcome of the findings of the Auditor General has compelled action of government in one direction or the other. There are circumstances where SHRAJ has been able to make pronouncements that has constrained government actions, but even beyond that, that has been able to constrain private action, but private significant action, such as corporate entities, among others. So there are circumstances where we've had control centers, institutions that are within the control centers, actually exert themselves in a way that have proven quite effective. But it is also important to note that not everyone is totally satisfied in that respect. And I think part of the reason may stem from the two things, some perceptual, and those perceptual probably fed by hard facts, and then some substantive. Perceptual, for example, stems largely from the the perception or the perceived, and I'll put this in an oxymoron fashion, but the perceived reality of the effect of appointments. For example, the appointments of the heads of these control centers. So, for example, part of the call for constitution amendment has targeted the appointment procedure. That who appoints, say, the Auditor General of Ghana, who appoints the Chief Justice, who appoints the OSP, for example, who appoints, the head of SHRAJ, the key heads of institutions. For a country whose politics has been very heavily patronage oriented, people have a tendency of assuming that whoever appoints the head essentially has control. And so what
are they wrong though?
Speaking as an academic, I don't like to normally make broad and categorical assertions without the evidence. So there's been no research, as far as I'm aware of, that has come to the effect that indeed that there's a connection between that perception and reality. But one thing which is clear about that perception is its persistence. That perception has been persistent for a long time, that the one who appoints the heads of some of these control institutions essentially has control over them. But in the case of the judiciary, that is difficult to push all the time, because there has been cases where governments have lost cases under chief justices that were appointed by the governments involved. And so that may tend to refute the allegation that the one whoever appoints the chief justice of the judiciary, for example, controls that. From a lawyer's standpoint, lawyers typically tell you that is not the case, because there's a professional understanding of the fact that a judge, whoever appoints a judge, doesn't necessarily have control over the judge, and the same extends to the chief justice.
Justice Atoguba talks about the Judicial Council and the fact that it's heavily appointment is directly or indirectly by the president, for instance. Is that an issue?
Well, again, it comes back to the question of the perception of whoever appoints, but that extends beyond the Judicial Council. The president appoints the justices of the courts. The president appoints, judges of the Supreme Court and judges of the judiciary, generally speaking, depending on the level. And so the question of the appointment, and that's what I'm saying, perception and reality. It is hard to say that because the president has appointed someone, that person is necessarily beholden to that person. But speaking from the standpoint of constitutional ethos, and particularly for evolution, the point I'm making is this perception has been persistent. It's been around for so long. And in the case of adjudication, there's a principle of justice not only being done, but being seen to be done. That is where the perceptual component becomes problematic, when it is persistent and therefore may need addressing moving into the future. The question is, if the president doesn't appoint justices of the court, for example, if the president doesn't appoint members of the Judicial Council, who should? I think that central question has not been satisfactorily answered. The problem has been identified, but the solution, not so much. Who should appoint judges? Should it be left to Parliament? But if Parliament has to appoint judges, Parliament of its own cannot just go about looking for who to appoint. There must be proposers. There must be somebody who starts the process. And even if Parliament appoints them, who completes the appointment process? Who signs off? Is it going to be the Speaker? Some of these things are easy to attack in terms of the problems they have posed over the years, but the solutions, not so much. And that's why I argue that the solutions may not necessarily be changing or tweaking the Constitution. The solutions may be us trying to understand and identify why it is that when particular persons make appointments, such as the president, there are perceptions that there are remote controls over the years. Because the problem lies in the perception, which unfortunately is fed by certain realities. And those realities may create the impression that it is indeed true that whoever appoints actually controls, even though that truth, if at all, may exist only to a degree and may actually have been exaggerated by reason of the perceptions that have fed that, and for which not much has been done to correct.
We're talking to Professor Kofi Abotsi, talking about the Constitution. And, let's stick with these control centers for a minute. Okay, and you gave an example, Mamavi, of the Auditor General's, office. This is supposed to be a direct control on the discretionary power of government. How well has it done in that role?
The Auditor General's office, as an office, I think I think we can fairly accept that it may have been fairly effective. And I say fairly effective because I think there has been times when the Auditor General has been assertive. There has been times when the Auditor General has been docile. There has been times when the Auditor General has been mixed assertive and mixed docile. Assertive to the extent that the Auditor General may have detected things and may have enforced them. Docile to the extent that may not have been so keen on asserting that detective authority that it has. And then mixed assertive and mixed docile to the extent that it may have actually identified some things, but it didn't move forward to ensure that those corrections are in place. The Auditor General's role, as may have been structured in the Constitution, is to ensure that not only government expenditure, but more critically, government finances, the management of government finances, public financial administration is carried out in a manner which is scrupulous and ultimately in the best interest of Ghanaians. Invariably, the Auditor General is likely to come against some headwinds from government because that's going to be an authority that is going to constantly call on government to rectify things. And so we have seen sometimes over the years in which there has been circumstances of challenges and refutations and clarifications and disputes, and one or two may have actually resulted in court actions. So that office appears to have done well to a certain degree, but it clearly has suffered a certain combative posture of governments, and that combative posture has created that sense of the Auditor General being there not only as a check, but almost as a police officer. But it's supposed to be a complementary institution. If you look at the Constitution and the way it's structured, it's actually supposed to help and advise government in the sense of the detective work it does, detective in quote, but it's supposed to advise on improprieties in terms of things that are supposed to be done in certain ways, particularly in terms of the legal compliance requirements not having been met, and therefore ensuring that government meets those thresholds. Like I said, the history has proven that there has been some problems and headwinds over the years, and this is one area that certainly can be improved upon to reinforce and intensify the control center, which is designed to ensure that the necessary power, again remember, it is necessary power, it is not power that can be taken away, it is power that should be necessarily exercised, but that necessary power is kept in check and is regulated by the control authorities.
Is it also a necessary power for the president to have the authority to appoint or disappoint people who lead independent institutions like that? Not just appoint and disappoint, but also to populate the boards that control their daily operation.
The president's appointment authority, we can all agree, is quite extensive. And in some cases, some can be dispensed with without much of a problem. For example, the president's constitution of the governing boards of public or state-owned enterprises. I don't see the necessity of that. In the minimum, we even have a board. We have an institute of directors in Ghana. We have other state regulatory bodies that can even assist in that respect, identify worthy, notable, and qualified citizens of states to populate those boards or entities. So for that, I would not characterize as a necessary power. I think that can be dispensed with without much. The difficulty is the portion dealing with the appointment of heads of these control centers. As I indicated, if we have to go for an alternative option, what are the preferred alternative options? And the reality is this. If you pay careful attention, the structure and architecture of our governance system is of such a nature that the president is at the core and center, in such a manner that even where he doesn't appoint anybody, if you give the power to other people to make the appointments, those other people ultimately will find their appointments connected to the president. So the X who is supposed to appoint on behalf of the state, that X ultimately may have been appointed by the president either directly or indirectly. And by reason of that, that person whose appointment you are trying to decouple from the president invariably will still be coupled or connected to the president. So if you do not resolve the worry of the ethos about the president's powers and authority, you would have still ended up, with the same result from which you're running.
Right. I want to, and Kojo, if I may, I want to just get your thoughts on the OSP's findings against a former Minister of States. And this was just 2 days ago when his report came out. And I want to read from the report. It says, though the conduct of Mr. Duboahin amounts to trading in influence or influence peddling, which is closely associated with corruption, there's no actual criminal prohibition of his acts, in respect of which the OSP has a mandate to further act. And, the question following this is, if this is not corruption, if this is not an area that the OSP can go into, what is trading in influence or influence peddling? And if it's not in our books, then what can we do about it?
Influence peddling, which fundamentally has to do, with basically just saying, I know X, and I can get you XYZ from X if you get me something, which is essentially trying to benefit from a relationship opportunity that one has by reason of a position one occupies. Essentially it is true that it is not in our criminal statute. So you can't find any such provision in a criminal statute that says if you benefit or exploit a relationship here with someone, you commit an offense. That of itself is not there. I think so if a charge is on influence peddling, there's no such offense. So you can't charge anybody for that. If the charge is for corrupting a public officer, that is an offense, and there's a law on that. The question then is whether the constitutive ingredients, whether the factual circumstances for the investigation supports a charge of corrupting a public officer. And the Criminal Offences Act specifically has a provision on corrupting public officers. So the offense of corruption has been an offense in Ghana. It's not recent. It's been an offense in Ghana since the 1960s. That if you corrupt a public officer, you commit an offense. But influence peddling, the way it is put, if it has to be characterized or framed as influence peddling, that's not an offense. And in that respect, of course, therefore, the OSP will be right.
But what about when you use your own public office for private gain? Are there no laws stated that make that illegal or criminal?
There are laws, and it depends on how, again, you frame the charge. And so, for example, the laws on causing financial loss to Ghana. That law on causing financial loss to Ghana, under some circumstances, if you follow what you just said, using your public office for private gain, it may actually have consequences on causing a loss to Ghana. It implicates conflict of interest. But there are things that are constitutional offenses, and then there are things that are criminal offenses. They are two different things, and they have different consequences. So constitutional offenses may result, for example, in your removal from office. Constitutional offenses may result in parliamentary opprobrium or sanction. It may result in all kinds of consequences otherwise than criminal prosecution. But the criminal or the statutory offenses per crime, those are criminal offenses, and those ones you have to find them in the Constitution. The problem with this is that Article 19 of the Constitution states clearly, under Article 1911, that you cannot charge anybody for an offense unless the offense involved is defined in the statute and the penalty stated. So for criminal, because of the threshold, the higher threshold, sometimes some charges or some things that may appear bad, all of us will agree that this is bad. You may not be able to pin or put your finger on a particular thing in the statute in terms of the criminal law that says this particular thing is a crime. So even though you find it bad, constitutionally speaking or broadly speaking, you may not be able to put a criminal angle to it, and that's the difficulty. So, as I said, if you characterize it as influence peddling, there's simply no offense on that. But if you decide to go on the angle or the route of corrupting a public officer, you may just have an offense in that regard, except that you will have to have the factual circumstances supporting that charge. Because every offense has the factual circumstances and sometimes a scenario given, which allows you to decide whether or not these facts support the charge or otherwise.
The call for a Conduct of Public Officers Act, is it the solution to some of these infractions?
As I indicated again, if you come up with the law on the code of conduct for public officers, and then you state in detail. Again, they may help in terms of the detail, particularly because you may also then have the opportunity of stating specific offenses that are committed whenever there's an infraction, and then potential consequences or penalties that are put in there. So it allows you to elaborate on all these. But again, all these do not necessarily resolve. The one thing we have to be mindful of is that particularly the offense of corruption, it is a consensual offense. Corruption, unlike many other offenses, is consensual in the sense that the parties involved are happy doing it together. So if you fight them with legislation per se, and we do not build the ethos, we do not build the inherent character trait of people, the tendency of public service, being public service. If we don't build that aspect, combating it with law would only go so far. There are so many statutes on our books that anybody barely gets prosecuted because nobody reports. And until someone reports, or until we have a whole investigation commissioned, nothing gets done. And so the way to get action on these essentially is to ensure that we build the ethos aspect and we ingrain it in our people. One of the things I worry a lot about today, and I have to say this is part of our problems of the problems of our current constitutional arrangement, is the fact that the civic education aspect of things in our current educational curricula, and again, it's not just the current, but for some time, how intensive is our constitution civic education of our young ones? Many of them are coming out of school with very minimal or scanty knowledge of civic education, and it is civic education that invariably results in good public service.
There are some who argue that we have an educational system that doesn't actually change mindsets. We've designed our educational system to help people pass exams. So it's not allowing, concepts of ethics and morality to actually stick. We are not giving people an education that can be practicalized. So is education really going to be the right tool to change mindsets so that we can have more constitutional minded people to choose leaders out of?
Education is powerful, and if you want to understand the effect of education, particularly in terms of ensuring a broad-based mindset shift in the country, just look at what China did with the Cultural Revolution, and how they've been able to move that country from an agrarian society to what it is today. And not just that, but it creates a certain sense of nationalism and a certain sense of nationhood in the country they have. Education is powerful, and it's powerful, not just the curricula, as you indicated, which allows us to pass exams, but it is one that we would have to use as a social engineering tool to get a mindset shift. Because I think one thing we all agree is that, look, we complain about corruption in Ghana today, but the reality is that we are all corrupt as a society. And it is the leaders we have, they are part of us. They were part of us before they got elected, and after they leave power, they become part of us again. It's us, which then means that if we complain our leaders are corrupt, we should look at ourselves and remember that we are corrupt. We birthed them. So there's a problem of corruption, and that problem of corruption, I think, partly derives from the fact that there's very little sense of attachment to the country. I think one thing we can't dispute today is that increasingly there's a detachment of the Ghanaian from Ghana. There's a gradual detachment of the Ghanaian from Ghana, where people are more interested in the self as opposed to the collectivity, the self as opposed to the nation. And I think part of that stems from the character of education that we have. The educational system, which is premised on, again, to borrow your words, one premised on passing exams, one premised just on becoming a lawyer, becoming an accountant, becoming an engineer, and there's very minimum content of that concept of Ghana. And that concept, so by the time the young one is out of school, he has very minimal attachment to Ghana. And the Constitution, we are talking about changing or reframing the Constitution. In my opinion, the thing we need to reframe are the actors or the managers of the Constitution. And those actors and managers, the future ones are in school at the moment, and we're doing nothing about them.
Can I just take you a little back to the OSP's issue? There's a provision in Act 29, the Criminal and Other Offences Act, which is Section 247, which gives an explanation to extortion, and it says a public officer commits extortion who, under colour of office, demands or obtains from a person, whether for public purposes or for personal gain or for any other person, money or valuable consideration which the public officer knows is not lawfully authorized, or at a time at which the public officer knows is not lawfully authorized, to demand or to obtain that money or valuable consideration. Does the OSP have the mandate to prosecute on Section 247, for instance?
The OSP has a specific mandate, corruption being the principal one. The OSP has a threshold of what character of corruption, for example, he can even prosecute. But the OSP's mandate is not limited. The law doesn't say that it can't, or he can't go beyond the act that establishes the office. And so it's an offense which implicates corruption, and once it falls within the threshold, in my opinion, the OSP can look at that.
Because Charles demanded a benefit.
Did he demand it?
Well, allegedly for now.
Well, and I'm just from the OSP's report.
It's still allegedly.
Yes. So
for now.
Yeah. So he you're saying he allegedly demanded it, but if I recall that video that was made public, did he allegedly demand it, or was it offered him? And does it make a difference?
He asked for specific percentages.
Did he
allegedly
demand it?
So does it?
Did he demand it?
But I guess the question that I just want to ask is 247. Does it come under the OSP's mandate?
As I indicated, the OSP has a threshold and a specific mandate under the Act establishing his office. I haven't seen anything in the Act that says that he can't prosecute outside of the Act itself. The Act speaks about the corruption that he should target in the threshold. So my opinion is, once the amounts involved meets that threshold, even under the Criminal and Other Offences Act, Act 29, I think the OSP can look at it.
That's interesting. Now, words matter. So, Mama V, you were quoting 247, which says a public officer commits extortion who, under colour of office, demands or obtains. So, in fact, whether or not he demands is not the point. It's whether he demanded or obtained. So that's of interest there. Some people are asking, did he demand it, or was it offered him? And whether that is of consequence. But the point is there something with which his actions, is there some charge under which his actions could have fallen that the OSP could then have concerned themselves with? Professor Kofi Abotsi, our conversation with you could probably extend the whole day if we allowed it to, but we're being signaled strongly that our time is up, which means that we're probably going to have to make a bit of a series of this so that we can talk more in the coming days and weeks and explore further what we can expect from political parties that are seeking our vote in 2024 when it comes to constitutionalism and governance. But until our next encounter, I want to say a big thank you to you for making the time to join us this morning.
Thank you for having me, Pedro, and Mama V.
Professor Ernest Kofi Abotsi, the Dean of UPSA Law School.